Hi, I'm John Hayes. I am a certified bankruptcy specialist in Los Angeles, California. I also am a adjunct professor at the University of West Los Angeles Law School. This semester, I'm teaching my basic bankruptcy class. It's the spring of 2021. And so this video is designed for my students, and I think it would be very helpful for new lawyers and any lawyers interested in getting into bankruptcy. And what I'm going to talk about today is secured creditors. What is a secured creditor? How do you get to be a secured creditor? What effect does that have in bankruptcy? And because of that, I think there may be state court attorneys, state court judges that would find what I'm going to talk about interesting. Bankruptcy lawyers, bankruptcy judges are authorities for the most part on what does it mean to be a secured creditor. It's a very important concept. Whether a creditor is secured is sort of the tail wagging the dog in the bankruptcy world. A secured creditor can and often does ignore the bankruptcy. So we'll discuss why. So let's think about it. I ask people, they want to file bankruptcy, and I've said over the years, well, do you have any secured creditors? And almost always they say, what does that mean? Rightly so. I don't know, what's a secured creditor? So I say to them, do you have anything where if you don't make the payment, they're going to come and grab the property? They're threatening you with that. We're going to take something specific if you don't make the payment, right? That's probably a secured creditor, or at least they think they're secured. So the client at that point will often say to me, oh yeah, the washer and dryer that we bought at Sears, our car, obviously, the house, obviously, but often it's, oh yeah, my wedding ring, my wife's wedding ring. We financed it somewhere, and they're threatening to come and get the ring. I've had clients with gigantic cameras, jet skis, the creditor who is secured as to the jet ski, the house, the car, the wedding ring are secured. What does that mean? They're secured by the asset. Secured creditors are sometimes called creditors that have a security interest in the property. In the bankruptcy world, they're called creditors who have a lien on property. Sometimes the creditor is called a lien holder. And what I'm going to talk about for the rest of this video is I'm going to use the word attach a lot. A lien attaches to property, specific property. And the fact that the lien attaches to something, bankruptcy doesn't change that almost ever. There's a few exceptions, but the lien that attaches to property in favor of a specific creditor does not go away in bankruptcy usually. So the creditor has the right to seize the asset that the lien attaches to without going to court, by the way. And we'll talk about that for a minute, but they can just drive up and take your car, the secured creditor. Why is that? Because you told them they could. You agreed that they could come and just take it. That right doesn't go away in bankruptcy, with a few exceptions. The right to seize the asset or get paid is binding on the trustee. And if the trustee ignores the property and doesn't try to sell it, the bankruptcy case ends, and the property still has the lien attached to it. All right, so it's not that unusual that secured creditors actually ignore the bankruptcy. Like, you know, why spend money? We're going to either get the asset or the money, one way or the other. You know, why spend money worrying about the bankruptcy case? The automatic stay at bankruptcy prevents the creditor from acting. In other words, actually grabbing the property. The creditor can't grab it without getting permission from the bankruptcy judge. That's called the automatic stay, but the lien is still there. So let's talk about this lien. I mean, how do you get a lien? How do you know whether you have a lien? As you can see already, I hope that being a secured creditor is a huge advantage to a creditor in bankruptcy, because this right to seize the property is not modified by the bankruptcy proceeding. So when we talk about how do you get to be a secured creditor, I want to tell you in advance that it's very technical. And the attitude of bankruptcy judges is that the creditor has to do it exactly right. There's no, well, I was close. You know, having a lien on property gives you such an advantage over everybody else that if you didn't do it right, you didn't create the lien, get it attached to the property correctly, then you're not secured. You're unsecured like everybody else, which means the asset can be sold by the trustee and the money distributed to everybody else, all right? So how do you get to be a secured creditor? Well, there's two ways. The first way, generally speaking, is called a voluntary lien. So the debtor, the person that owes the money, voluntarily gives the creditor a lien. And then there are involuntary liens. Involuntary liens are created by law, by the government, by our Congress in Washington, D.C. has created liens, for example, in favor of the IRS. You know, the state of California has created a whole bunch of liens. So there's voluntary and involuntary. So let's talk about voluntary. That's why I like teaching law, I'll tell you, because I'm going to tell you in 2 sentences, basically, how you get a voluntary lien that applies in most cases, and almost all cases, really. At the same time, I could write a 500-page book article on that would flow from these 2 rules I'm going to give you. It's like a tree, you know. There's exception after exception after exception, but the 2 rules I'm going to give you apply almost all the time. So what are they? Rule 1, there has to be a written agreement that describes the collateral. Usually it's called a security agreement, but it's a document. I give you a lien. I agree that if I don't pay that loan back, you can grab my car and sell it and take the proceeds. All right. So there has to be a written agreement with some exceptions that I might mention in a minute. And rule 2, The agreement has to be properly perfected. The creation of the lien has to be properly perfected. That is very complicated. You know, for you lawyers out there, if somebody comes to you and says, I'm going to loan my brother-in-law money, you know, do the paperwork, it's going to be secured by his business, his liquor license, run the other direction. I would personally never take a case like that because there is so much chance that I wouldn't do it exactly right. And if you don't, you're not secured, you're unsecured. All right, so that this is perfection. What does that mean, perfect a lien? The general idea is that perfection is doing something, almost always filling out a form and recording it somewhere. The idea behind the form and recording it somewhere is to tell the world that there's a lien, give notice, so that the next guy who's going to loan money on the same asset can find out whether there's already a lien or not. So there's an agreement that is properly perfected. So let's think of an example. I want to borrow $10,000 from my partner, Matt Resnick. He has a lot of money, you know. So, Matt, can you loan me $10,000? And he says, well, John, what are you going to give me for collateral? I say, you don't trust me, you know, I'll pay you back. No, I want collateral. All right, well, I'll give you my truck. I have a truck worth $10,000. I'll give you my truck as collateral. So he says, all right, do the paperwork. What's the paperwork? We have to have a written agreement, 1 page. I hereby agree that Matt Resnick has a security interest, has a lien on my truck. Here's the identification number, the lien, the VIN number, whatever. He signs it, I sign it. Then we have to properly perfect that. How do you perfect a lien on a vehicle? Well, you do it at the Department of Motor Vehicles. I mean, at least in California. I don't know exactly how you do it anywhere else. So we sign the agreement and we fill out some form and take it to the Department of Motor Vehicles. I've never done that. I don't know. I mean, you buy a car from Toyota, you know, and Toyota does all the paperwork. But one of the things they do is they record something at the Department of Motor Vehicle, and that perfects the lien that you gave them when Toyota Motor Credit agreed to loan you the money to buy the vehicle. All right, what about a house? Matt says, you know, I don't know about that truck. You might hide it or something. Give me a lien. I want a lien on your house. It's the same thing. You need a written agreement. I'll give you a lien on my house, and something has to be recorded. So the way that's done is the form is called the deed of trust, and the deed of trust identifies the property. It says I give Matt Resnick a lien, and the deed of trust, that's the agreement. I sign it. I've voluntarily giving him a lien on my house. That deed of trust is taken to the county recorder's office in Norwalk and recorded. That perfects the lien that I gave him in the deed of trust, in the security agreement, in this case called the deed of trust. What about another common? You go to the bank and you want to get a loan and you say, I'll give you a lien on my accounts receivable. I'll give you a lien on my equipment. I'll give you a lien on my business. You know, well, same thing. There's a document called the security interest. It describes the property, accounts receivable, equipment, furniture, intangibles, I sign it, the borrower signs it. How do you perfect that? It's a form called a UCC1, and that's recorded at the Secretary of State's office in Sacramento. If you go onto the Secretary of State's website, it's actually, they just set this up in the last few months, but you can, you type in any business name, any entity, LLC or a corporation, you can type in the name of the entity and you have to find it on the website, but boy, instantaneously, it'll show you everything that's been recorded at the Secretary of State's office, which is almost entirely UCC1s, but you can get notice immediately. So, you know, and I'm trying to get a loan on my car, Matt can find out whether I've already given somebody else the loan. Why does that matter? We'll talk about that. I mean, why does it matter? Can two different creditors have a lien on the same car, the same house, the same property? And of course, it's just one's first in priority. The next one is second. The next one is third. How do you know who's first, second, third, fourth? Almost always it's whoever perfected first. The stamp on the deed of trust, on the UCC1. They're first. All right. How about involuntary liens? The most common involuntary lien that people tell me about when they're considering bankruptcy is the IRS. Congress in Washington said that the IRS, they need to collect all this money, right? They will give them a lien to help the process of collecting the taxes that are owed, right? So there is no security agreement. I didn't give the IRS a lien. The government gave the IRS a lien. It still has to be perfected, though. Actually, technically, it doesn't have to be perfected. I don't want to make this too complicated. They have a lien whether it's perfected or not. The lien just has priority over nobody else until it's perfected. Well, actually, even then, they don't have priority over anybody else who's already perfected. With a couple of exceptions, you know, almost every sentence I'm saying, I think, oh, geez, maybe I ought to, you know, I can think of an exception, but so the IRS gets a lien according to the Internal Revenue Code. And that lien covers everything: your clothes, your furniture, your cars, your retirement, your house. They perfect it by recording a notice of lien at the county recorder's office. That gives the IRS a lien on everything you own. The next most common involuntary lien, I would say, is what's called a judgment lien. So I don't pay my American Express bill. They sue me, they get a judgment. American Express can record a form at the county recorder's office. The government says, the law in California says a judgment creditor can get a lien. Now, I didn't give American Express a lien, but when they get a judgment, the legislature has said American Express can get a lien by recording a form at the county recorder's office called an abstract. Once the abstract is recorded, a lien on real property located in the county attaches to the real property. Well, can a judgment creditor get a lien on personal property? Sure. They have to record a form in Sacramento at the Secretary of State's office. And as soon as that form is recorded, I mean, the clerk stamps filed, a lien attaches on all real property located in the county. And again, now when, if I file bankruptcy, entities that have liens on my property have the right to seize the property that the lien attaches to. And that doesn't go away in bankruptcy. Judgment liens can go away in bankruptcy. I'll do a different video to discuss that. But there are a lot of other involuntary liens. There's a thing called mechanics liens. That is really technical. Do not try to do that yourself. I mean, there is such a good chance that'll be screwed up. For one thing, even if you have a lien, it's, as I understand it, it's only good for 60 days unless a lawsuit is filed. But anyway, so that's involuntary liens. So maybe in summary, how does this work in bankruptcy? Well, when you file bankruptcy, an estate is created. The property that you own becomes property of this bankruptcy estate. And if the property has a lien attached to it, it stays attached in bankruptcy. So the creditor is stopped by the automatic stay from trying to seize it, but the lien doesn't go away. All right. I might tell you one last thing about voluntary liens is, I don't know why it just popped into my head, but pawn shops. How about pawn shops? You go on, here, I'll give you my watch, my wife's wedding ring. That's kind of an interesting question itself. I mean, who owns the wedding ring? I can't give somebody a lien on something I don't own. But I give them my watch and they give me $100 and I give them a lien on my watch. I tell them, if I don't pay you back, you can sell my watch. How is that perfected? Well, remember I said you have to have a security agreement. One exception to that is possession. So a creditor can perfect a lien on personal property by taking possession of the personal property. So when I give Matt a lien on my truck, I could give him possession of the truck. I'll drive it over to his house, park it in his driveway, and he'll keep it until I actually pay him back, and then he'll give me the car back and the lien is released. And that's the way it works with pawn shops. They keep possession. The last thing I want to talk about is how does it actually work with seizing? When a secured creditor wants to seize the property, how does that actually work? So I don't pay Matt Resnick. He, comes in the middle of the night and takes my truck when I'm not looking. Now, that doesn't mean he owns it. I still own it. But under California law, he has the right to sell it. And that's a complicated area. There are two different ways to sell property. You have to give notice, but he can sell my truck and take the proceeds and apply it to the loan. What if he doesn't sell it for enough, though? What if he only sells it for $6,000? Can he still come after me for the other $4,000? Again, that's a very complex question. What that's called is a deficiency. Can Matt sue me? Can he sell the truck, get the $6,000, and sue me for a deficiency? With respect to personal property, at least in California, the answer, as I understand it, is basically yes. You can sue me for a deficiency. You have to jump through a bunch of hoops, make sure you did the sale right. What if he sells the truck for more than $10,000? Somebody buys it for $14,000. The other $4,000 would go to me. That's why they do this, is if it's worth $100,000, you know, he doesn't get a $100,000 truck, he only gets his $10,000 back. And the rest of the money would go to me. What if I got a loan from my brother-in-law and I gave them a lien on the truck after I gave him a lien on the truck? Well, if he sells the truck, if Matt sells the truck for more than $10,000, the additional proceeds would go then to whoever's second, if there's enough to whoever's third. What about a house? How do foreclosures work? I'll end with that. In California, once again, it's very technical and it's form intensive. But the bank, you know, I have a mortgage on my house. I don't make a payment. The bank wants to have a foreclosure sale. They have to record a form called a notice of default. The notice of default will be sent to me by certified mail. It's a long form. It has a lot of fine print. But what it says is, Hayes, you are in default of the agreement we made where you gave us a lien on your house. You're in default. We're giving you notice that you're in default, and we're giving you 90 days to cure the default. So how does that work? What's the default amount? We call it the cure amount. So if on my house, if I'm 5 payments behind times whatever the payment is, say $2,000. So I'm 5 payments behind, that's $10,000. That's the cure amount. If I paid them $10,000, I'm not in default anymore. So the notice of default says you have 90 days to cure. And they give you an amount. That's the cure amount. And they say that amount is going to go up with each additional payment you miss until we have our actual sale. But you have 90 days to cure. At the end of the 90 days, another form is sent to you, and it's called a notice of sale. And by the way, again, this is in California. I don't know how it works anywhere else. But the notice of sale says we're going to sell your house on a specific date, roughly 30 days later. You know, March 21st at 11 o'clock, we're going to have an auction. The auction will be somewhere. Here's the address of where the auction will be. It can be wherever they want it to be. And it can't be in New York. I'm sure there are rules that, you know, it has to be around somewhere in the area anyway. But the notice of sale says we're going to sell your house at this date and time to the highest bidder. All right, now, one point about that is people call us all the time and we say, did you get a notice of default? And most of the time they say, oh, the foreclosure sale's next Tuesday. They didn't want to wait till the last minute, you know. But we say, well, did you get a notice of default? And they confuse that with letters from the bank. Look, buddy, calls they've been getting. You're in default. You got whatever. They can send you letters, call you, do whatever they want. They must file that notice of default and give you the 90 days after that. Then another 30 days before it's going to be sold, roughly 30 days. All right, so if no notice of default has been filed, you're 4 months away from a foreclosure sale. We actually have this internet thing we use. I'm not sure how it works, but our office, I can find out whether a notice of default has been recorded within minutes. Client calls, I can find out whether there's a notice of default, while we're talking. If there isn't, I don't care what the story is, you have 4 months. before the foreclosure sale. Now, how does the foreclosure sale work, though? Well, usually it's the bank, the first. Let's say they're owed $200,000. Up to that moment, that includes all the payments and all the interest and late fees and attorney's fees, whatever else they have the right to charge you under the contract that you signed. Let's say it's $200,000. The bank will bid $200,000. They don't have to bring a check so that they can pay themselves, you know. It's called a credit bid. The bank will credit bid the amount it's owed, $200,000. If somebody wants to bid $210,000, they have to bring the money. As I understand it, they don't have to actually have a cashier's check, although they might. I mean, I've never bid on property at a foreclosure auction. I did go to one once that was held by the sheriff, but my understanding is the foreclosure trustee can say, you want to bid $210,000, bring the money tomorrow. Especially if there's 2 or 3 people bidding, especially if it's a lot of money. Anyway, if somebody comes and bids $210,000 and they bring a check, cashier's check for $210,000, they become the owner of the property. $200,000 goes to the bank to pay them off, and $10,000, you know, after all the costs, $10,000 goes back to the owner of the property. Again, to, you know, protect the owner from getting the value out of the house beyond the amount that's owed to the bank. All right. One last thing. How does it work, these foreclosure sales? How does it work when the second is having the foreclosure sale? So widely misunderstood how this works. So the second files a notice of default. We're owed whatever, here's how much you're in default. They don't get paid. Notice of sale is recorded. Now there's the foreclosure sale. By the second, the foreclosure trustee is selling on behalf of the second, not the first. What the foreclosure trustee is going to sell is the property subject to the first. The bidders don't need to show up with enough money to pay the first. The creditor who's in second place is owed some amount. Let's say they're owed $50,000. They will bid $50,000. Let's say the first is $1 million, whatever. That lien isn't going away in this sale. So if the second is $50,000, the creditor will bid $50,000. What's it bidding on? It's bidding on property subject to $1 million first. What if somebody else shows up? They bid $60,000. Well, then they become the owner. They have to bring $60,000. They become the owner of the property subject to the first. How does that work? If I show up and I bid on a house, I become the owner of the house. I write my check for $60,000. And now I own a house subject to $1 million first. Does that mean do I owe $1 million to Bank of America? I mean, obviously not. I didn't sign any promissory note saying I'll pay Bank of America. But the lien didn't go away. The Bank of America has the right to do their own foreclosure sale, and they will, unless I pay them, or I get my mother to pay them or something. Their right to seize that property is not affected by a sale by the second. Sales by the third, it's the same way. The first and second stay. The foreclosure sale is of the third. What happens if the first is having the foreclosure sale, and there's a second and a third. How does that work? The foreclosure sale by the first wipes out the liens of the second and third and IRS and the mechanics. Forget I said mechanics lien. The judgment lien, the IRS lien, any liens behind the first. If the first has a foreclosure sale, any liens behind the first are wiped out by the foreclosure sale. That's why banks rarely will take voluntary. I mean, there's a form called a deed in lieu of foreclosure. Banks don't want those because the foreclosure sale wipes out anybody behind them. So the bank becomes the owner of it, unless somebody overbidded what the bank's credit bid. The bank becomes the owner of the house, and they all of a sudden have clean title. Anyway, what about a deficiency? What if the bank is owed $1 million and somebody comes along and bids 900,000? The bank could bid 901,000, but the bank may want the 900 rather than owning the house. So the bank says, all right, we'll take 900,000. Can the bank still sue the borrower, the homeowner, for the deficiency of $100,000? That I'm going to punt on and just say it's a really good chance the answer is no. There are a bunch of exceptions that say the answer is yes. That's beyond the scope of this. The last thing, I think I've said the last thing 5 times now, but this really is the last thing. If the person that shows up to buy the house and they say, I bid whatever, some number, and the foreclosure trustee is conducting the auction, says, all right, anybody else want to bid? All right, you're the successful bidder. Here's a deed. You are the owner now of this real property. Well, the owners are still in it, right? You have to throw them out. You have to, do an unlawful detainer and evict them. What if there's unpaid property taxes? The county can do their own foreclosure sale, and that wipes out everybody. The county taxes are always first. Why is that? Because the government said if you don't pay your county taxes, the county can sell the property free and clear of everybody. All right, so I'm going to leave it at that. Whatever you do, don't make decisions. This is designed for law students. It's a very complex area. I hope I've convinced you of that. Don't make any decisions based on what I'm telling you. This is really designed for law students in a bankruptcy class. What happens in bankruptcy? It's very helpful to at least have some general idea of what is a lien. A lien's a big deal in bankruptcy. You know why? Liens don't go away in bankruptcy. A lien stays attached. All right, so creditors will call me. Hey, I'm a secured creditor. Wow, I'm impressed, Send me the security agreement. Send me the written document showing that my client gave you a security interest, a lien in the property, and send me the document showing that you properly perfected it. Because until then, you got to convince me you're secured. All right, so I'm going to post this on YouTube. If you like it, click like. If you have any questions or comments, put them in the comment section. And I love talking about this sort of stuff, and I'll be happy to try and answer you. So thanks a lot. I'll see you next week. I'm going to talk about what is property of the estate mean. All right, bye-bye.